Good morning and welcome to the second day of our July docket. As you know, yesterday we were at the federal courthouse in Kansas City, Kansas. And this case, which was originally set for yesterday, was continued until today via Zoom on the mutual agreement from counsel, and we appreciate your cooperation on that. This morning we have one case on the docket. And each side, as you know, will have 15 minutes. After I call the case, I'll want you to announce your appearances. And then, Mr. Kraft, I think you represent the appellants. I want to know at that time whether you want to reserve any time for rebuttal. Just so you know, my name is David Bruns, and it's my pleasure to be the presiding judge this month with this esteemed panel. On my left, at least on the computer screen, is the Honorable Gordon Atchison, who's been on our court since 2010. I came in about a year later than him, and believe it or not, now we are two of the longer serving judges on the Court of Appeals. And one of our fairly new members is joining us today. We're honored to have Judge Leslie Isherwood, who was appointed in 2021 and has been with our court since that time and was actively involved in appellate practice for many years with the Sedgwick County District Attorney's Office before joining us. So it's great to have this panel together, and we will call the case of Surface Companies, Inc. versus Pishny Real Estate and Michael Surface. If you would state your appearances, please.
Eric Kraft here on behalf of Surface Companies, Inc. and Michael Surface.
Bob Berg on behalf of the defendant appellee, Pishny Real Estate Services, LLC.
And Mr. Kraft, would you like to reserve any time for rebuttal?
I would like to reserve 4 minutes, Judge.
4 minutes, so 11 and 4. So I'm not actually looking at Facebook or anything. I'm going to be looking at my clock on the phone. And when you're ready, you may begin.
Thank you, Judge, and may it please the court. This is a commercial. I know you've read the facts, but this is to give a summary. This is a commercial landlord-tenant dispute between Surface Real Estate, Surface Companies, Inc., and Michael Surface, who I referred to in the brief, and I will today, is referred to as Surface collectively, and Pishny Real Estate Services, LLC, who I will refer to here and in the brief as Pishny. Just to set the stage for this dispute, I'd like to go over a few of the facts. Pishny is a restoration business. It was grossing nearly $5 million in revenues, and it was growing rapidly, and it possessed a new order from the federal government to restore 500 windows, which were sitting in storage, waiting to do the job. Pishny needed a new space. It needed a bigger space. Now, although Mr. Pishny, the principal of Pishny Real Estate Services, had been looking for a new space, he was running out of time and running out of options. So he looked at Surface's space. Now, he considered this to be subpar. He categorized it as dumpy when he first came to it. But time was running out. So instead of investigating the suitability of the space, Pishny rushed into a contract to lease the space without determining whether the space was suitable for its operations, its particular specific business. Now, Pishny was at the property 3 times for a total of about 1 to 1.5 hours. During one of these visits, Mr. Pishny asked Mr. Surface about a demising wall, the wall that separated the space that would be Pishny's with the space next door. He thought it was incomplete, and he asked if the city allowed that. The court found that Mr. Surface said that he didn't need to finish it yet until he got a tenant on the other side. Mr. Pishny, not believing that entirely, put the obligation to work on the wall or to finish the wall on Surface in the lease, Exhibit A. The second comment relates to a fire suppression system, a sprinkler system. Pishny had looked at several properties. He knew some had sprinklers and some did not. He asked, does the city require this building to have a sprinkler system? To which the court found Mr. Surface answered no. It's a metal roof and a metal walls. So no. Now this conversation, which happened for less than a minute, one time, and it was never repeated verbally or in writing, never documented, serves as the true basis for this dispute. Now, the trial court found that that statement about the sprinkler system was fraudulent, based upon some emails that Mr. Surface had exchanged in a discussion about the building and its fire suppressive systems or lack thereof with the city of Lenexa. The trial court created from this decision a near fiduciary duty upon Surface to act in the best interest of his tenant rather than himself. He stated that the trial court indicated that not only must you answer the question that was asked, which Surface did and did honestly, you must also interpret that question, read the questioner's mind, and advise that tenant, even if it's against your own best interests. The failure to do so was fraud. Now that was, as shown in my brief and discussed here today, that's an error that this court is invited to correct.
Can I interrupt you there? I wanted to ask about the interconnection between the fraud decision and the breach of contract claim that you brought. As I understand it, your position is if we reverse on the fraud claim, we then need to address the breach of contract ruling. Is that correct?
I think this court can do that. I don't think it's a necessary part of this court's decision. I simply point that out in my brief because with this court's findings, as I envision them, none of the other claims that Mr. Pishny or Pishny Real Estate asserted can survive because they have coextensive elements. And that leaves us only with a breach of contract.
Which is the claim your client originally brought and then spurred the counterclaims. All right. Is the converse of that true? If we affirm on the fraud, do we even reach the other claims, including the breach of contract claim? Or do they fall out?
Well, I think they fall out, Judge, but I would, because the fraud and the other claims raised by Pishny are coextensive. They all seek the same amount of damages and they're all for the same activity. They were just alternative claims. So those claims definitely do fall out. Now, this court, if it found fraud in the inducement of the contract, I don't know that I could enforce the contract against Pishny other than to pay rents that may have been due for the uses that were already there. There's not a huge dispute that Mr. Pishny used the property for approximately almost a year.
And he paid rent on that. I mean, he was not delinquent in the rent, correct?
That is true.
Okay. Well, and that's all. I'm not asking you to concede, obviously, your argument on the fraud. I was trying to see how they interconnect. It wasn't entirely clear to me from the briefing on either side, and that helps me a lot. So go ahead.
Well,
Absolutely.
before you leave that issue, because I had a question about that, I'm glad Judge Atchison asked that. They did bring, if I recall correctly, a breach of contract action as one of their counterclaims. And again, not getting you to fall on the sword, but would you agree that you could have a misrepresentation or some type of comment that's made that could constitute a breach of an agreement, but would not necessarily rise to the level of fraud?
I think that I don't think that that's possible, Judge, because the statements that were made here were all pre-contractual. And there's an integration clause in the contract which excludes all those previous statements. So unless they were fraudulent, I don't think that they can be considered in a breach of contract action. Now, the parties dispute more than just the statements. They also dispute the standard of review. Pishny would like to limit the standard of review to that of a very narrow, light most favorable to Pishny, with that a rational fact finder could find the same way as the judge did, that it's highly possible. Now, that would be the correct standard of review if we were challenging the facts as found by the district court. We are not. And in doing so, in making that argument in its brief, Pishny completely misses the point of our argument. We argue that this court's review is unlimited because we're challenging the actionable nature of the facts as found by the district court. In other words, these facts, even left undisturbed from the district court's finding, cannot constitute fraud.
I saw the dispute there on the standard review and looked at it. Your argument makes a lot of sense to me. I'm not sure how it reconciles, though, with In re BDY, where the Kansas Supreme Court sort of retooled the whole clear and convincing standard. And it seemed to suggest the standard that Mr. Berg is asking us to use. And I'm looking at it recently, it seems to kind of collapse findings of fact and conclusions of law into a single appellate standard. What are we supposed to make out of all that?
Well, I think that's an interesting point. I think that conflicts with Waxy, a case that I cited heavily in my brief, in that the actionable nature of the facts is not a question of whether the facts are correct. It's assuming that the facts are correct, and it's applying the law to those facts. So if in any other case, the application of law to facts as found by the trial court deserves an unlimited standard. This court is not going to assess the validity of those facts or that whether or not somebody was telling the truth. And I would be foolish, really, to try and upset those facts. But if you look at the facts as they were found and apply the law to those facts, I believe that an unlimited standard of review is appropriate.
Okay, why don't you go ahead and with your substantive argument, and we'll sort out the standard of review here at some point.
Certainly. And I think I'm just about out of time.
Well, you're almost to your 11 minutes, but we've asked you quite a few questions. So take a couple more minutes here and try to wrap this portion up, and then we'll give Mr. Berg a chance.
I think the main point I want to make is that we've got I want to talk a little bit about Waxy, the case I cite in my brief. Waxy says that the question and answer in a fraud claim must be precise. Waxy involved an individual that was applying for health insurance while he had HIV, the predecessor virus to AIDS. The questionnaire, he answered honestly by saying he had not had any symptoms of a blood disease. He had not, because he didn't at the time, he was not taking any medications for that disease, which he wasn't at the time, and that a doctor had not diagnosed him with that disease because a clinic had, not a doctor. Now, the Supreme Court said, you know what, you may have wished, and ideally he would have been a little more honest, a little more forthcoming about this disease, but it was not his responsibility to give those facts up. It was the responsibility of the insurance company. And although the insurance company wished that he disclosed more, they didn't ask the right questions. Just like in trial, if I don't ask the right question, whether that question is right or not, the answer can't be fraud because he honestly answered the question.
Let's say, let me follow up on Waxy a little bit. My understanding of Waxy over the years is I've tried to make sense of it is that part of that, it depended on the unequal bargaining power between an insurance company and a consumer, which of course we don't have here. And or tell me if I'm wrong. To here, it seems like we have two experienced business people who are, on pretty equal standing. But there, it seemed like they were relying pretty heavily on the fact that it was an insurance company who would have perhaps a little more experience in business than a consumer. So, any thoughts on that?
Yes, I think that is a factor. And when there is unequal bargaining power, more latitude is given. But the fundamental instruction is true, that the question must be, the answer to the question has to be truthful, but the question has to be precise in order to constitute fraud. You can't simply say, does the city have a requirement for a sprinkler system in this building? Mr. Surface answers no, and it didn't, and it doesn't at the time, and I don't believe it does now. There is no requirement for a sprinkler system. There were discussions. There were some preliminary discussions and preliminary determinations, but no requirement had ever been entered. No order had ever been entered requiring a sprinkler system. So Mr. Surface answered honestly to this question, which again lasted less than a minute and was never touched again. And instead of investigating any suitability for this, Pishny moved in, started operations, and then later found out that a municipal ordinance, of which it is presumed to know the law, a municipal ordinance stating that a woodworking shop in excess of 2,500 square feet is required to have a sprinkler system. So it was the use here, as opposed to the building. The use of that building is what required a sprinkler system here, not the building itself. And that's an important distinction to make.
So your position is his answer was a truthful answer.
Correct.
It was not, the building in and of itself was not required by code to have a sprinkler system.
That is
and
correct.
It was only the fact that a woodworking shop was coming in that would be. Okay. Well, why don't you wrap this part up, and that way I'll give you some time for rebuttal, and we can hear from Mr. Burke.
Certainly. And yeah, the last thing I would like to emphasize is it is difficult to kind of separate these two standards, the use of the building as opposed to the requirement of the building itself. Either one can be a requirement for a sprinkler system. Here it was the use. And I've argued that that is an intervening superseding cause, which interrupts even if you find the statement to be fraudulent, even if all the other elements are met, that intervening superseding cause of the requirement of the use of that building is what caused the damages, not the statement itself. And with that, I'll yield my time for rebuttal.
Okay, thank you, Mr. Burke. And I'll give you extra time if you need it, as our retired colleague, the Honorable Joseph Perrin, used to say, you don't need to use it, but we'll give you a little extra time if you need it.
All right. Good morning, and may it please the court, counsel. I'd like to begin by thanking the court for accommodating the parties with this special session. It's greatly appreciated. It's my intent that my comments today are going to be brief, subject to questions by the court. The facts and the issues in this case, I believe, are extremely straightforward. This case does not present any new or novel issues that have never been decided by this court. So it's not plowing new ground. This case is a classic textbook case of fraud. Now, as you have recognized, we filed several counterclaims. The district court chose to award judgment on just one of the counterclaims or causes of action. That was for affirmative fraud. But we also had causes of action for negligent misrepresentation, fraud by silence, breach of contract, and rescission of contract based on mutual mistake of fact. The court entered judgment on the claim of affirmative fraud only, stating that the other causes of action would just simply be duplicative and would include the same damages. The court also said you can't have a representation that is both fraudulent and negligent at the same time, and that's true. So the point that I'd like to make, of course, is that those other causes of action really were never decided upon. In the event that this court would reverse, for some reason, the district court's finding of fraud, those other causes of action really have to be decided upon by the district court. They were really just passed upon. Now, let's talk about what the court did do. The district court found after a 3-day trial that Pishny's evidence and the witnesses were credible, and found that Mr. Surface made 2, not just 1, but 2 affirmative misrepresentations. First, that the demising wall that separated out the 2 sides of this property did not require approval from the city of Lenexa until there was a tenant on the other side. And second, that automatic fire sprinklers were not required at the property because the property was a metal building with a metal roof. And Mr. Surface said that he had previously had a tenant there that operated as a cabinet shop for 10 years, and there was no requirement of a sprinkler system at that time. This court, applying what I believe to be the appropriate standard of review, does not reweigh the credibility of the witnesses, and it has to view the evidence in the light most favorable to Pishny in this case. If you'd like to ask some further questions on the standard of review, now might be an appropriate time, but I believe that it is clearly decided now by the Kansas Supreme Court that in any case in which the trial court or the finder of fact has to make a decision on a cause of action that requires clear and convincing evidence, the standard now is set forth in BKD. This court has clearly said that that also then means that it applies in fraud cases. And I've set forth what I believe is the standard of review. Now, to his credit, Mr. Kraft wants to cast this case as if this is an unlimited standard of review because the claims involve whether they're actionable or not as a matter of law. I appreciate his arguments on this, but this is not a case in which the standard of review should be unlimited. The misrepresentations are actionable. You would have a case, for example, if the misrepresentations involve promises of future events. Those
let me ask you about these specifically as the judge found them. As to the first involving the demising wall, what is the injury to your client as a result of that, assuming it is a misrepresentation, and it does appear to be? How was your client harmed?
And this is important because in this case, the appellant's brief deals almost exclusively with just the misrepresentation pertaining to the sprinklers and not the demising wall. It's very important because the demising wall goes hand in glove with the requirement for an automatic sprinkler system. When Mr. Surface constructed the demising wall 3 years prior to this lease in 2015, he was immediately cited by the city of Lenexa for a code.
And let me back. I wanted to ask about that too.
Okay.
Does the record reflect whether the citation is for the failure to get a permit or because of some defect in the wall that it doesn't satisfy code, notwithstanding the failure to get a permit?
Well, you have to file a permit, and he never did that. And so
I understand that.
Yes.
Is
He was cited.
there something in the record that says there's a problem with the wall besides the absence of a permit?
No, because you'd have to get a permit first approved, which would take care of whether it was built in compliance or not, and that was never done. So
Okay.
I believe the citation was you never got an approved permit.
Okay, well, I distracted you from my other question, which was,
Yeah.
how does the whole business with the demising wall, how did that cause some actionable harm
Because
to your client?
Thank you for the question. Because it goes hand in glove with the requirement to install an automatic sprinkler system. We have attached to our appendix to the brief as Exhibit A3, which was Trial Exhibit 123, an email from the City of Lenexa Building Inspector, Matt Souders, to Mr. Surface. And in that email, and this is just a couple of months before the lease was executed, the City of Lenexa specifically says that due to the unpermitted, unapproved demising wall that was added in 2015, fire sprinklers are required for the front building, and this was the space. So that's what creates the problem, is that when he built a demising wall that wasn't approved, according to the city, that kicked in. It says present tense, are required. It kicked in the requirement for a sprinkler system. And when the City of Lenexa sent out its notice of violation on July 31, 2019, it cited that. That was one of the notices of violation. You don't have a sprinkler system in there. 13 days later, Mr. Surface sent a notice of breach to my client saying you have to correct all of these items cited by the City of Lenexa, even though he conceded at trial many of the items were not his responsibility, but including putting in a fire sprinkler system, and you have to do it within 10 days. So he was being required or cited as a breach of the lease for failing to put in a sprinkler system when the requirement for the sprinkler system, according to the city, was due to the unapproved demising wall. Hope that answers your questions. If you have anything further, I'd be glad to answer that.
Well, I guess I'm not seeing, though, the connection to a precise injury to your client. It sets off this debate about who's supposed to pay for it when the city is saying you got to put it in.
Thank you. That's fraudulent inducement. If Mr. Pishny had been told that by Mr. Surface, you need to know that in March of 2018, a couple months prior, the city is taking this position. And if you enter into this lease, there's going to be a requirement for a sprinkler system. He would have passed. He never would have entered into that contract. That's the damage.
And let me ask you about the second finding of fraud related to the statements about the sprinkler system when they were in the building. I think it was the third time doing a walkthrough before the lease was signed. Mr. Kraft says that Mr. Surface was entirely honorable and forthright and was honest as Abraham Lincoln. Why is that mistaken? I mean, was it not a fair answer to a fair question? And why not?
It absolutely was not. If we're talking about now just the automatic sprinkler system misrepresentation.
Well, that's what I'm asking about.
Yeah. Okay. Yeah. He was specifically asked, and the trial court found that the question was, are automatic fire sprinkler systems required at this property? Mr. Surface, although at trial he said that conversation never occurred, his answer to our counterclaims admitted that it occurred, as we said it was in the trial court.
Well, that's beside the
Yeah.
point.
I know. But he answered, he said, no, sprinkler systems are not required at the building because of metal building, metal roof, previous tenant. That's exactly contrary to what the city of Lenexa had told him 2 months prior, when it says fire sprinklers are required for the front building. So it is an absolutely false statement. Does that answer?
Okay.
Okay.
Well, that answers my question. I don't know if
Okay.
it satisfies me necessarily. but-
Okay. I anticipated that there might be some questions on the whole subject of, was there justifiable reliance on this statement? If the court has any questions that I can help out.
I have some questions along those lines. I mean,
Yeah,
two things. One is, does due diligence come into play? These are two businessmen that are dealing with each other, which relates then to what you just referred to is, was there justifiable reliance? Because even if we assume all these facts are gospel, we still have to make sure that they rise to the level to meet the elements of fraud. So if you
Correct.
want to hit on that a little bit, I'd appreciate it.
yeah. The seminal case, as I mentioned in our brief on reliance as an element for fraud, is the Goff versus American Savings Association of Kansas case. That case cited with approval the restatement of torts second, section 540. There have been subsequent decisions by this court, and I may have this mispronounced, Sippy versus Christich. And there's another case, and that is Jacobson versus Campbell Excavation. The net of these cases is that the standard is, according to Goff, that a recipient of a fraudulent misrepresentation is justified in relying upon its truth without investigation, unless he or she knows or has reason to know of facts which make his or her reliance unreasonable. The test is whether the recipient has information which would serve as a danger signal and a red light to any normal person of his or her intelligence and experience. The court then talks about section 540, which says you have no duty to conduct, even if you had you're justified in relying on a false statement, even if your investigation would have revealed contrary information. And then section 554 says reliance is not justified if the party knows that the statement is false. Let's apply that to this case. Mr. Pishny did not know of these previous communications that Surface had with the city of Lenexa. Mr. Pishny did not know that there were actually, that he had been cited numerous times for code violations at the property pertaining to the demising wall. Had he known that, you can't just simply rely on the statement by Mr. Surface if he had actually been in possession of information that was to the contrary. His reliance, of course, is a question of fact. That's a factual issue as to whether reliance is reasonable or not. What Pishny did was he asked Mr. Surface affirmatively, is code approval required? Has it been approved? He said, no. Mr. Pishny then took one additional statement. He just didn't, or one additional step. He didn't just simply accept that statement blindly. He insisted on including paragraph 7 to exhibit A to the lease, and that is trial exhibit 144, appendix exhibit A1. And in the lease, Mr. Pishny specifically required Mr. Surface that he would correct any code violations existing at the property when the other tenant, the existing tenant, moved out. So he did have justifiable reliance. He took the step to protect himself to make sure, notwithstanding Mr. Surface's comments, Mr. Surface had that obligation to do that. Now, Your Honor, Judge Bruns, you asked, I believe, can you also have a cause of action for breach of contract, even though the underlying misrepresentation doesn't arise to the level of fraud?
I did ask that.
Yes.
So I would appreciate your response.
Well, thank you. And yes, you can. Now, Mr. Kraft says, parole evidence, things prior to the contract or merged into the contract. You can't do that. That's not what we're talking about here. You can have a breach of contract based simply on paragraph 7, exhibit A to the lease that I've just mentioned. And that's what the court found, is that Mr. Surface was the first party to materially breach the contract because he failed to remediate or correct existing code violations of the property when the existing tenant moved out. So he found, as a matter of fact, that Mr. Surface was the first party to breach the contract. Unless the court has any additional questions that I can entertain or help with, I'll yield the remainder of my time.
Any other questions from the panel? If not, thank you, Mr. Berg.
Thank you.
Mr. Kraft, I'll give you some time for rebuttal.
Absolutely. Thank you, Judge. With all due deference to Mr. Berg, he wants to change the facts where he wants to change the facts, and he wants to leave the facts where they are when that suits him. First, even the district court found that the demising wall was too far removed from the damages to Pishny to have caused it. That was a finding of fact made by the district court. The demising wall caused Pishny no proximate damages. And the reasonable reliance question, I know we've talked a lot about Restatement 540, and the district court relied on Restatement 540, but they completely ignored Restatement 541, which requires an investigation. And in fact, you've got Eckholt versus American Business Information, where in the District of Kansas in the federal court, where they make a point that the aggrieved party made repeated inquiries about a situation that was ultimately found to be fraudulent. In Wygand, they said that you cannot rely blindly when a cursory examination would show that this was a fraudulent statement. And in KV Trucking, the district court, the 10th Circuit, required a full investigation rather than just a cursory investigation. So what Mr. Berg would have this court believe is somebody comes to me and says, I've got the contract to paint the lines on the George Brett Expressway here in Kansas City, and I want you to be the flagman for it. But all you got to do is you got to pay me this fee. And a simple look in the paper would have proven that to be false. But he's not required to do that, according to Mr. Berg. He can blindly follow whatever he wants. He can bury his head in the sand and still allege fraud and be successful. And I don't think that's what the courts in Kansas do. Even in Safety Technologies, which is also cited, they conducted an investigation. Now, the fact that they conducted an investigation was important in Safety Technologies because they conducted it, but they couldn't find the answer. They tried to get the answer, but they couldn't get to it. And therefore, the court said, you did everything you could to try to disprove this statement. You did everything you could to try and check it out. You did your due diligence. It's fraud. Mr. Berg said one thing in his statement that something about it wasn't needed to be, the city said in the exhibit that he quoted that if you're going to lease this property, you're going to need a sprinkler system. That is wholly untrue. That is completely false. The city simply said, under a hypothetical situation, you're going to need a sprinkler system. But they also admitted at trial that they never ordered it. They never required it. And in fact, in July 31 letter, 2019, the city cited the lack of a sprinkler system to both Mr. Pishny and Mr. Surface. But when Mr. Pishny moved out of the building, that requirement was removed, indicating that it was Pishny's use, and they agreed with this at trial, it's in the transcript, the use of that facility is what caused the need for a sprinkler system. And that was it. Once he moved out, there was no requirement for a sprinkler system. So you can't say that Mr. Surface not only has to know the Lenexa code and reveal any dispute he's ever had about code application with the city to any potential tenant who asks anything in relation to possible code violations. He also has to know which codes apply to the businesses that are wanting to be tenants. He has to know the tenant's business intimately in order to properly advise the tenant. That's not the law. That creates a fiduciary standard on a landlord, and that cannot stand.
Why don't you go ahead and wrap this up, since we've given you quite a bit of time, but I want you to be able to make your closing comments, and then if the panel has any other questions, they can certainly ask.
Absolutely, Judge. And I detail this in my brief. 4 of the 5 elements have not been proven of fraud. And if those elements are coexistent with the other claims made by Mr. Pishny or Pishny Real Estate, then those claims can't stand either. If this court finds that the proximate damages are Mr. Pishny's lack of a fire sprinkler system for his business rather than for the building, and that proximate damages aren't here, that Surface didn't cause them, then those damages can't be part of any other of the tort claims that Mr. Pishny claims. So I think this court has an obligation to look at this, and I, of course, disagree with the standard review. You have the opportunity to correct this because it imposes a standard far too high on a landlord. And with that, I'd ask the court if they have any questions, and otherwise I'm...
Any questions from the panel? If not, thank you both. Good arguments and good briefs. We appreciate when we have 2 good experienced counsel. It's enjoyable to hear the arguments, but we'll try to get this decision out to you as quickly as we can.